Hi, everybody. Welcome to this episode of Trial Alchemy. And this is going to be my interview with Skip Babbitt, part two. So, Skip, welcome back again. Skip Babbitt is a guy who is a very experienced plaintiff's civil trial lawyer who is a member of ABOTA, and he has tried a lot of jury trials, primarily auto and other PI kinds of cases. And so we're going to continue our discussion today because there's some more topics I'd like to discuss with you. So thanks for being back again, Skip. Good to have you.
Always good to be here with you, Monty. Always good to be here. Fire
All right,
away. Fire
fire
away.
away. So the next question is this. As a plaintiff's lawyer who does a lot of auto cases, one of the things that you've seen a number of times in your cases is you may have a case where you think the negligence is pretty clear and the defense is fighting all issues of negligence, causation, damages. But when you get to trial, all of a sudden they're saying, oh, we want to stipulate to liability. And you've dealt with that situation and you've got some approaches that you take when that happens. So let's hear about that. When the defense lawyer tells you, hey, Skip, when we try this case, we're going to stipulate to liability. You go, okay, let's do it.
You know, my thinking on this starts back in discovery phase. We get an answer to the complaint on let's just say a rear ender at a red light, with about as clear liability as you can get.
Right.
They deny the claim. They got 18 affirmative defenses in there as to why they're not responsible. Hell, they even throw in equitable defenses like unclean hands and latches and things like this. That tells me right off the bat they don't know what they're doing. But other than that, they're denying liability on a clear rear ender. Got it, got it, got it. Then you send them written discovery. And all you get back, whether it's form discovery, special logs, request for admissions, is an objection to every word about that long. The objection takes out about a paragraph and a half. I mean, they don't know what the word you means. They don't know what the word intersection means. They don't know what the word, speed means. Your vehicle hit my vehicle. Which vehicle are you talking about? Vague and ambiguous. We get this all the time. You send requests for admissions. You admit you told the police officer at the scene of the collision, and you cite the statement from right out of the traffic collision room. Admit you told the police officer this, that you were at fault, da 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 da. Once again, the objections, the denials, I was in shock, the whole thing. Then we get up to trial. And it's a clear liability case, and you're not going to law and motion court on this stuff because it's just not worth it. And they're going to stip eventually. So then you get up to trial, TRC, level about a month before trial. Yeah, Skip, we're going to stip the liability. So you are. Well, guess what? Liability is not my cause of action. My cause of action is negligence against your client. Are you stipulating that your client was negligent? No, 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 because we still have substantial factor and damages and da da da, but we're stipulating liability. I refuse your stipulation. What do you mean? Well, the judge is going to order it, and this is what you get. And you tell him, no, I stipulation is an agreement between the parties. I don't agree. But here's what I'll do, because I understand what you're at. I am going to write out a list of facts that I want your client to sign off on that she stipulates to, not you, your client. And literally, I go through my same request for admissions that I had done like 9 months previously. You admit on this date you were driving this car. Admit that my client was stopped at a red light at the intersection of Pershing and Georgia Street. Admit that you were inattentive. Admit that your inattention caused you to rear end my client who was stopped at a traffic signal light. And I pretty much go this. These are the facts. You want to stipulate liability. I need you to stipulate the facts. Facts that constitute a cause of action. And my cause of action is negligence. And, you stipulate plaintiff was injured. Not how much she was injured, how much the medical bill. Stipulate that she was injured. Gets you past the substantial factor. And they'll come back. Well, we can stipulate, but we can't stipulate she was injured. That calls for medical opinion. No, it does not. Not only that, you've got all the information. Your DME doc says she sustained injuries, dude. What are you doing? This is what I get into with him. So I back him in the corner. You either sign this statement of facts that I can read to the jury during my opening statement, or I don't stipulate and I put my whole case on. Okay. And I draw the line. I have a right to put on my entire case. And I'm not stipulating to what they are. My cause of action, liability is just an element of negligence. Action is unstable notice. Monty, are you still there?
Yep.
Okay, we're back on. So in any event, they'll want to pare it down and shape it down. And some of the things I'll take out and pare it down. Then they try to take the position, well, since we've stipulated liability, you don't get to talk about the accident because that's just a waste of time. Nobody's going to talk about the accident. Now, here was their primary intent. When you get a rear end collision or clear liability collision, the defense does not want any of those facts coming in. They want to change the dynamics of the trial to where basically now I'm defending my client against their attack on my client's damages, is what happens. And that's what, when they stipulate the liability, they're trying to do is take the
Right.
sting or the bite out of their side of the case, causing the collision. I make them own it at trial, one way or another. Okay. But even if that you do get to the point, okay, we'll stipulate all these facts, da da da, and then they say, but now I'm going to do emotional elimination. You don't get to talk anything about how the accident happened or what happened at the accident scene or anything like that. I said, first off, no. Um, my client hearing your car screeching behind her is part of her emotional distress damages. My client being thrown around inside the vehicle is substantiation on her injuries. You know, my client, freaking out at the scene because she's trapped inside of her vehicle. The airbag went off and there's smoke or dust or whatever in the car, and she thinks it's going to catch fire is part of her non-economic damages. I have to discuss how her body moved around and what she hit inside the vehicle, for causation of why her neck and back and shoulder and arms and elbow hurt.
Yep.
So, so this is the fight on stipulated liability. Um, it is a two-edged sword. And truthfully, stipulating the liability takes a lot of the what I'm going to call the out of the plaintiff's case. You want to put on the defendant. You want to put on at trial. You want to put on the defendant and get her or him on the stand to say, yes, I'm at fault for this collision. I've gone as far when I put somebody on the stand like this where I wouldn't stipulate the liability. I get them on the stand. I said, first question. Mr. So-and-so, you admit you rear-ended my client's vehicle at a red light, correct? Yeah. You're owning this accident, aren't you? And I've asked it just like that. You're owning. Objection. I beg ambiguous as to owning. Judge said, no, counsel, I think we all understand where Mr. Babbitt's going with this. And that's the best thing you can ask for. So once again, stipulated liability is a two-edged sword. There's a trick up their sleeve.
Yep.
And it's not favorable to you, the plaintiff's attorney. You want to make them stipulate the facts and facts that constitute issues, which is your cause of action. This stipulate the liability means nothing. It just means nothing, and it hurts the plaintiff's case. You don't get to put on your good stuff.
Right.
Especially if the defendant, has denied everything on special rogs and requests for admissions, and you get them on the stand and they say, when you ask the liability question, they start, well, sir, let me read to you your responses to requests for admissions that you signed under penalty of perjury. Admit that you rear-ended my client at a stop sign. You denied that. How come? Your answer says denied. How come? Admit you were going 45 miles an hour where you ran into my client's vehicle that was stopped. You denied that one too. Well, I wasn't sure it was 45. It might have been 40. Okay. You agree that you're going 40 when you rear into my client and stop and stop that. Yeah. So this is the games you can play. You stipulate the full liability and you get a judge, and some judges will say, yeah, Babbitt, you don't need to put up any witnesses or evidence regarding how the accident happened because they've stipulated liability. Just move on, go right into damages. You don't want that. You do not want that. And there are
Right. That's a
judges that
risk you
will do
face.
that. There are judges that will do that.
Yep.
So those are the pitfalls of stipulating the liability. Remember, you do not have to stipulate the liability.
Right.
Judge cannot force you to do that. He cannot force you to do that. Judge, I have a right to put on my client's entire case. And the liability section is going to take about maybe an hour, Judge. And this is a 4-day jury trial. Come on, let's do it.
Right. Well, in terms of plaintiff's case, but it's true in all cases, um, isn't it your experience that if the jury hears the defendant and if the jury doesn't feel they're being honest or weren't in the case, and if they start to dislike them, that's going to help you and your client?
That goes back to what we talked about last session, the popularity quotient.
Yep.
They like your client and they'll give you whatever you ask for. Even if you've got a bad case, they'll give you what you ask for. You have a great case, but they don't like you or your client for whatever reason, they won't
Right.
give you any money. It's a
Right.
popularity quotient, is what I figured, Monty. So you've got to be the one they like, and your client's got to be a likable client. I have settled cases for 60, 70 cents on the dollar just because the client wasn't trial worthy. You
Yep.
know, they're going to make a bad impression. They won't listen to me. You know, I don't want to go to trial and have them blurt things out that is going to kill their case when I've got 40, $50,000 of my money invested in their case. So you
Right.
settle those ones. So it's popularity quotient.
Yeah, that's a good way to describe it. And I think when I was a young lawyer, the hubris you can have as a young lawyer is you can think as you're developing your skills that I can take somebody who's not likable and somehow fix them up. But I found that doesn't really work.
It does not. It does not.
Yeah.
People are who they are. And especially in a courtroom setting. I prepped trial for a client for trial for a day and a half. You think they got it down. We've gone over their story 100 times. You've made them repeat their story 100 times. You've told them their story 100 times. You've gone through it. They get on the stand. Hell, they can't even remember their name. You know what I
Yep.
mean? You know,
Yeah.
and then let the defense attorney say, "Isn't it true that on December 25th, 2022, you complained of neck pain to your doctor?" I don't remember. I don't know. So no,
Yep.
prepping your client is very important. But there are people that no matter how much you prep them, they're not going to get it. So you got a
Right.
choice to make. Do I go forward with this guy and just try to clean it up as I go along, let the jury see who he is, and then explain it in closing argument? And, sometimes my client makes mistakes, like we all do.
Right.
Or do you say, let's think about resettling this case?
Yeah. But on the likability issue, when you're first interviewing that potential client, if you don't like them, don't take the case. I mean, because you probably can't clean them up.
Monty, during intake, I tell my clients all the time, we've got to get along. You've got to return phone calls. You got to show up when you need to show up. You need to go all your doctor's appointments. I can't do those things for you. These are things you got to do. We have to be a good match. This is going to be a partnership that we're going to be on the road for maybe anywhere from a year to 2 years long and possibly go to trial. If we are not a good match, this will not work. And you got to let them know right off the bat. And that lets them know, okay, I either got to cooperate with Mr. Babbitt or move on and go somewhere else. Because you get the people that come in here and say, my next door neighbor wasn't even hurt in an accident. She got $100,000, and I'm really hurt. My back's sore. My chiropractor said my back might be sore for the rest of my life. Should get $2 million. Wow, you know
Yep.
who's your
They're
friend's
out
attorney?
there.
Who is your friend's attorney? You might want to give them a call because
Yeah. Well, great. Let's move on to another thing that I know that you've done. And it's not quite 10 years ago, I don't think, but I think it was around 2016 that California adopted some new laws allowing expedited jury trials, and I know that you've done those. So let's hear a little bit about your experience. Are expedited jury trials, in your opinion, something that lawyers should consider doing? And have you found them to be something that you have been successful with? And what are the benefits and the risks of them?
Monty, you probably remember as well as I do when we started practicing law, there was the Superior Court and there was the Municipal Court.
Yep.
Two different courts, two different judges. One had lesser jurisdictional damages limits than the other. We had
Right.
municipal court judges, they weren't Superior Court judges, they were municipal court judges. They
Right.
have to get elevated to go to the Superior Court. And trials would go like normal, 3 or 4 day jury trial, even for a smaller case. And it was 2003 or four when they first came out with expedited jury trials, but they were only 1 day. Okay, you can only have 1 day, which literally gave you about 4.5 hours to try your case. Okay, same thing, 8 jurors, 6 out of 8 for a verdict, but you only got 1 day to put on your case as well as the defense. So it just wasn't enough and time, and a lot of people weren't using them. And I'd done a couple under that scenario and said, God, these are easy to do. It's like doing an arbitration in front of 8 jurors. The rules
Right.
of evidence are relaxed. You could submit declarations of your doctors. And what I would do is take the medical records, turn the medical records into a declaration. You know, um, I, Dr. So-and-so, am the treating physician for so-and-so. I first saw him on June 2nd, 2010. He complained of, and then you put whatever the history is in there, boom. And you write that all as declaration, have the doctor sign off on it. And you could not only just submit that at trial, but you could read it to the jury during your opening statement or anytime during your case in chief. Okay, because it's admitted into evidence. You can read, and then you read it to the jury, and the defense doesn't have an opportunity to cross-examine your expert, which is a nice thing too. Some of our experts do not testify well.
That's right.
They just don't. A lot of our treating docs on the plaintiff side are not litigation savvy. They are
Right.
not. And on the defense side, they're using docs that have got more jury experience, more jury trial experience than like probably 80% of the plaintiff's attorneys in town. Do you know what I mean?
Yep.
You got those guys. And they are seasoned and they are vets. So when you're thinking about going to an expedited jury trial, this is all of the things that go into the hopper that make you decide, am I going to do this or not? The limit was 2000 or up till this year, 2024. The limit on an expedited jury trial was $25,000. They've now raised it to $35,000, which is a good thing. Okay. 25,000 was just a little hair shy of what you'd want to do. You could, we're not fortune tellers. We really don't know a lot of times how much the cases are going to come in with. I mean, I've had cases with $2,000 in medical bills. I've gotten verdicts of $50,000, $60,000.
Right.
Um, Unfortunately, the both plaintiff and defense attorneys think the value of their case is based on the amount of the economic damages, medical bills, and lost earnings. If you're thinking that way, you're losing like 80% of the value of your case. The value of your case is based on your client, whether they like them, whether they don't like them, and what happened to them during their life and how well they can explain it. So
Yep.
when you're thinking about an expedited jury trial, you got to think, how much time am I going to have to put on my client to tell her or his whole story? Because you don't have 3 hours, you don't have 2 hours, you don't have an hour. You got like
Right.
45 minutes for your client, and they're the star witness, type of thing. So these are things you got to factor out. Now, because it's up to $35,000 now, the limit there should be a lot more filings these, and the courts like these. In 2016, a law came out where it extended the expedited jury trials to 2 days instead of just one. Well, that made a big difference. And here's how that happened. I get a call from CAOC, California Attorney or Consumer Attorneys of
Consumer Attorneys of California.
California. Can't remember the gal's name, and I know her in it, but in any event, and she calls me. She says, "Skip, I know you don't know me, but I understand you've done some of these expedited jury trials down in San Diego. Where the law sunsets in 2024, and we're moving to renew it. We got a legislator that's on board and da da da. But is there any fixes to this that you think we need? Oh yeah. So he goes, okay, we're gonna have a committee meeting. 2 weeks later, we have a committee meeting. 10 people on this committee. And
Hmm.
I'm asking her, I'm kind of quiet because I'm new on this committee and da da da. And I'm hearing all this. Well, what about this? What about that? Da, da, da. And finally, I said, "Has anyone here tried one of these expedited jury trials that's on this committee?" No, but somebody in my firm has. Okay, let me explain. We need 2 days, period. One day is not enough. If it isn't 2 days, let the dang law sunset because nobody's using it. You know what I mean? So I got that in. I got in the declarations. You need declarations from the doctors. I mean, paying a guy, you got a case that's worth $15,000, $18,000, and they're offering you $5,000 on it. You want to go to trial. Your doc's going to charge you, ER doc will charge you $5,000 just to show up. You know,
Right.
you don't beat your 998. Well, you just ate, half your verdict,
Yep.
type of thing. So we need more stuff. Boom, boom, boom. So anyway, I got on the made it on the bill, got passed. It's 2 days, and we were going for $50,000 as the limit for expedited jury trials, and they compromised and they said, we're going to do 35,000. So good enough, good enough. But let me explain these expedited jury trials. When I saw that new law pass out in 2016 for 2-day jury trials, I said, okay, I'm going to take some cases, smaller cases I generally don't take, and I'm going to do several of these. And I'm going to invite everybody on the Consumer Attorneys of San Diego's listserv to come and watch and see how they're done, especially young lawyers. These expedited jury trials are perfect, you know, cut your teeth on for newer attorneys. Your first trial should be an expedited jury trial. Um, your first 3 to 5 as a new attorney should be an expedited jury trial. Evidence
That's my thought exactly. I
Mhm.
agree.
So I do one of these, the first 2-day jury trial, I do in front of Judge Pressman, probably about 6 months before he retires. Great judge.
Hmm.
And Mark Stenson from Farmers was my defense counsel. We were good buddies and we were friends, so we got along well in trial and out of trial, whatever. And Judge Pressman says, I've heard about these expedited jury trials. How do they work? I said, well, let me explain, Judge. And I told him the law and how it worked and da da da. And then he goes, great. He's taking notes. I goes, okay, good, good, good. Let's get this on. So we put on an expedited jury trial, get done in, like we were done the morning of the second day. So
Right.
then they go out for deliberation. We get a verdict back that afternoon. Awesome, Monty. Awesome. No 2, 3 day waits. I mean, make it simple. Because these cases should be simple. They're not, they shouldn't be complex. If they're complex, you put it in unlimited jurisdiction.
Right.
So anyway, about 3 weeks later, I'm doing another one in front of Judge Dato when he was still on the bench. You remember Judge Dato? He's now on the Court of Appeals.
Yep.
And same thing, same defense attorney, Mark Stenson. Farmers was making me try everything, and I was kind of pushing it because I wanted to do these things. Yeah, these expedited jury trials, and I'm getting attorneys in the back, doing, watching. So Judge Dato comes out and he says, Counsel, I heard from Judge Pressman. He did his first expedited jury trial about a month ago or so, and he said these are great, but how do they work? And what's the status? I said, that was our trial, Judge Dato, Mr. Stenson and I. It was our trial with Judge Pressman. And he goes, Oh, great. How do they work? Same thing. Gave him the whole spiel of how they work. It's 8 jurors, it's 6 out of 8, it's, everything's shortened. You can submit by declaration on your doctors or even a witness if you want to. Boom. You can that law encourages counsel to stipulate to all the issues that you usually don't. No one will stipulate to in a longer trial because you got to get this thing done. You got 2 days type of thing, whatever. So anyway, we told Judge Dato how it all worked. He goes, great, great, great. Cute little story about that trial with Judge Dato is because there's only 8 jurors that were impaneled, or they
Right.
bring in 16, and you get to impanel 8. And it's funny, Judge Jado says, because courtroom seems almost empty with that few people in there. Judge Jado says,
Right.
counsel, I hope you don't mind, but I'd like to ask a favor of you. Mark Stenson and I go, sure, Judge, what's up? He goes, do you mind if I do the judge's voir dire from the well? I've never done a jury trials on my own, but do you mind if I do it on the well from the well on this one? And I look over at my defense counsel and says, I don't know, Mark, what do you think? You should we let him? And I look back and I said, Judge, this is your courtroom. Of course you can. You do whatever you want in here. He goes, oh, thank you, counsel. Thank you so much. So he did his voir dire from the well. We did a 2-day jury trial. I had about 10 attorneys in there watching the back, see how, in the back, how they work. 2 weeks after that, I'm doing a third one in front of Judge Taylor. Judge Taylor, Mr. Babbitt, I understand you've been leading the charge on these expedited jury trials. I said, well, I'm just trying to, give my clients what they need and hopefully teach some other attorneys how to do these. He goes, yeah, I noticed you got a gallery in the back there. There's like 25, 30 attorneys because I've been posting these on the listserv. This is how they work. They're great. They're easy. You get your verdict like the next day, type of thing. So anyway, we do this in front of Taylor, and he's a stickler for the rules. He had read the rules too. He had read the law too. He knew the whole thing gambit inside and out.
I expect that from him.
So anyway, during one of the breaks on the end of the first day, at the afternoon break, jurors are out, and he says, Mr. Babbitt, are these your trial groupies in the back there? I mean, 25, 30 attorneys back there. I said, Judge, no one is more surprised than I am that somebody would want to come and watch me try a case. And he goes, okay, it's getting too thick in here. I'm going to take my break. So anyway, but we did those. About a week or so after that one, and you got to realize I just done 3 of them in about a month and a half. Do you know what I mean?
Yep.
You can do those. I ended up doing 6 of those in 3 months. Just the scheduling thing. And about a month after I did the trial with Judge Taylor calls me here in the office. You get a call, secretary says, Skip, Judge Taylor's on the phone. And your first thinking is, oh, what did I this time? Do you know what I mean? So anyways, he says, Skip, you and I are going to do an expedited jury seminar for the county bar, and it's this date and this time. You're going to handle the perspective from the attorneys, and I'm going to handle the perspective from the bench. So I'll see you there at the, bar center, da da da. He didn't ask. He told me, and
Yeah.
and I respected that. We ended up doing it twice. We did one downtown. We did one up in North County. So Judge Taylor and I put on the expedited jury trial seminars for everybody. These are great for younger attorneys or small cases or cases you don't want to put 10, 15 grand into to get experts there and stuff. These expedited jury trial is the way to go. The fact that they lifted the ceiling to 35,000 is a bonus. Once again, I wanted 50, but 35 I will take. I take cases every now and then that are of that value, mainly former clients or a referral from a former client. You always take those cases no matter what, because that's how you get more.
Yeah.
When they get the son or the uncle or the next door neighbor that got hit by a semi on their motorcycle, they'll think about you and they'll call you. So that's why you take some of those smaller cases sometimes. But in any event, I speak highly of the expedited jury trial process. It's easy. You're more comfortable. There are fewer jurors there, so you feel more comfortable. They feel a little more comfortable. It's not that crowded courtroom. The trial goes fast. You are in and out of there before it even starts, it feels like. Motion and limines are you keep those to a minimum in an expedited jury trial, and the judges will tell you. One of the kickers that
Don't you
is
only get about 3 per side in
you
that?
get 3 per side, yeah, something like
Yeah.
that. The kicker on an expedited jury trial is it's not appealable.
Right.
Okay, so you get a bad verdict, you get something bad that happens during trial, whether it's the judge's fault, the other side's fault, or whoever's fault, it's still not appealable. So you can't appeal the verdict or the judgment or verdict in an expedited jury trial. But you're not dealing with that much money.
Right.
That's the blessing on that. That is definitely the blessing.
So your opinion, younger lawyers, not that experienced, great way to get your training, great way to learn how to try cases, and even for experienced lawyers, great way to maintain your chops.
Absolutely. Absolutely. I mean, like I said, I did 6 in about 3 months. And, you know, this was the year I did 14 jury trials in 18 months. But when you go to your bigger trials, you're honed. You're still in the game. You go a year or two, if you're a trial lawyer, and I mean a trial lawyer, not a sum lawyer, but you're a trial
Right.
lawyer,
Right.
you got to stay on your game. It's not like riding a bike. Okay, you got to stay on your game. You got to stay on it. When you Trial lawyers get into trial mode, and it usually starts about a week or two before the trial starts. Your brain's going 1,000 miles an hour. Your body doesn't hurt like it normally hurts at our age anymore. You're
Yep.
smart. You're thinking. You're waking up early. You're going 1,000 miles an hour. You're in trial mode. At the end of that trial, whether it's 2 days, 4 days, 2 weeks, or a month, you need like 3 to 4 days to decompress your brain. Do you know what
Right.
I mean? And we kind of talked about that before. With these little small jury trials, decompression is a lot shorter, and you stay honed, you stay
That makes
sharp, you
sense.
stay razor edged. Do you know what I mean? Because it's the same questioning, it's the same issues, it's the same evidence code. It's just a shorter time frame.
Now, Skip, in my experience, and I probably learned this more from the arbitrations I've done, but in jury trials and all kinds of trials, you're better off if you can get down to the most important things and just make it short, to the point, and get there and get it done. And I think a lot of lawyers think, oh, the longer I take to try the case, the more important it's going to be. I think they lose a jury. So isn't there a great value in learning how to distill things down to the most important points in these expedited jury trials?
Awesome point, Monty. Awesome point. When I'm teaching trial techniques, I'm always telling people, look, you might have 10, 15 things that you think you can impeach somebody on. Boil it down to your best five. Okay.
Right.
Well, in poker, you play 7 card stud, you discard 2 cards and you play five, right? There's a reason for that. Okay. Same in jury trial. You want to boil things down, especially these expedited jury trials. You got to boil things down. You don't have a
Yep.
lot of time. You got to boil them down. And you learn to, like you said, distill your case down to the key elements and the key points. And you don't have to repeat them. You boom, it's in and out. And that's one of the better training parts because it teaches the lawyer doing these things. I don't have a lot of time. I can't go into this long scope
Right.
of questioning. I got to keep it short.
I
And
got to
and
get it done.
that plays over when you do a unlimited jury trial, whether it's 2 weeks, 3 weeks, 4 days, or
Yep.
whatever like that. You learn how to distill things. And what you should be picking up on as a trial lawyer when you learn how to distill things is the jury gets it. They hear and they see everything. They get
Right.
it. You know what I mean? If I can give one quick little side story on the jury getting it, okay, and that they see
Let,
and hear.
let, let me ask you
Okay,
this before
but
you give that story, and that is, I've always thought since the expedited jury trials started to be allowed that it's something that could be even effectively used, not just in smaller auto cases, but if the parties were willing to stipulate and agree. I think it's a useful tool for things like contract cases, other kinds of cases where you can put something on in 2 days. Again, a great way to keep the cost down, get to the essence, get a decision. What are your thoughts and reaction to that?
absolutely. For like a contract case is basically going to be a bench trial anyway, because these are
Yep.
questions of law, not fact, generally, whatever. So no. Now, a lot of judges don't like bench trials. They got to work. They got to pay attention to the whole thing. They got to take copious notes. They got to make a decision that they know somebody's going to be pissed off about no matter what. So a
Right.
lot of judges try to shy away from bench trials. But no, you do an expedited jury trial or whatever in a bench trial type thing. The judge is going to love it because he's going to know we're going to be in and out of this. The attorneys have got to distill and boil this down. It will be good. So yes, all kinds of trials, can do an expedited.
Now, I think we may have talked a little bit about the jurors getting it in part one of your interview. And maybe if you'll allow me, I'm thinking to go into another topic
Sure.
area, and that is, you're representing the plaintiff typically in your cases, and your plaintiffs are injured, and you're taking the case to trial. And one of the risk factors for all plaintiffs, in my experience, having tried cases on plaintiff and defense side, is, a plaintiff, if they're talking, the only one talking about their injury and what's happened, can start sounding like they're kind of a complainer and a whiner, and the jury won't like that. So I'm sure you use a tactic, and I'm sure I know what your tactic is, but how do you tell the story to the jury of how your plaintiff has been hurt and can't do the same things and their life has changed? What's your approach and how effective is it?
I call them damage witnesses. They weren't at the scene. They don't know about the accident, but it's the wife, it's uncle, it's a coworker, it's a friend of the family, it's you know the dad that always goes is every son's baseball game and knows all the other dads there, type of stuff. Because that's what happens on Little League and basketball. And I know this. They form a dad's club,
Yep.
and you know that you want to get those people in. You want to get those people in before your client even testifies. And that is my gig. I get a damage witness up there when it's, go through liability, then it's time for damage witnesses. And I call, spouses are good, but juries will kind of go, that's their wife or husband they got in on. The defense attorney will ask the spouse, you've got a financial interest in the outcome of this case, don't you, Mrs. Smith? And
Right.
objection, argumentative, maybe sustained, maybe not, da, da, da. And they do that stuff. So, but you still got to bring in a spouse, period. But it's the outside witnesses that help. It's the one that doesn't have a stake in the game. It's the one
Right.
that's known your guy for 5, 10, 25 years since kindergarten or whatever it was. You know what I mean? Who can say, look, we used to do this, and this like weekly, man. This was our gig. This was our thing. Get hall passes from our wife. And on Saturdays, boom, we went mountain bike road for 3 hours. You know what I mean? We done Mount Soledad. We done Cowles Mountain. We done, before there was Scripps Ranch or the Mira Mesa area, or it was all hills. We did single track. We did all this stuff like that. Hell, he didn't even get on the bike anymore. You know what I mean? That's the witnesses that help you. You know what I
Right.
mean? And you
And
call them
that's
before your client gets up and testifies so that they've said it for your client.
right. Right. Let me ask you this about your client. Is it, in my experience over the years, but you've been trying cases more recently, if I was on the plaintiff side, I always felt that if my client, the injured party, came across more stoically and they're just trying to say, hey, I'm getting along with life and this and that, I think that worked better with the jury. Do you find that still to be the case?
Yes and no, depending on the incident. You want them, you want to show that they're doing everything they can to try to get better. Okay. And I don't mean the client that has gone to chiropractor now for 3.5 years every day because, my back's going to hurt the rest of my life. Not that guy. But,
Right.
the guy with, the broken arm, the herniated discs, the radiculopathy, the brain injury and stuff like that. You want them somewhat stoic because whining is not good for the plaintiff.
No.
Nobody likes a whiner. Nobody likes a whiner. And you get these minimum impact cases or whatever, and if that client says, 2 years later, 3 years later, you're in trial, and my neck still hurts, and I can't do this at all, and I can't do anything, well, you're gonna, oh shit, I mean, because now you got to rebuild, and that hurts. So, well, it kind of goes back to, our original discussion on is the client trial worthy?
Yep.
Is the client trial? You know, Stoicism is good, but then again, I've seen guys take it the other way. Men, especially in the personal injury world, men our age especially, like to be what I call the hard guy. I don't need any treatment. I can just go to the gym and exercise. I don't need physical therapy. Nah, we kind of need a physical therapist to evaluate you to come into trial and say how bad you're. Well, I can do that. I don't need that shit. I'll just go to the gym and do my regular routine because that helps me more than physical therapy. And so you get that guy, the
Yeah,
hard guy, and you got to sit him down and teach him the facts of life. Going, look, everything you just told me diminishes the value of your case. If you want to do it your way, we might as well just settle for what they're offering right now because I don't see
yeah,
it getting much higher. What do you
yeah.
want to do? You follow my lead or not follow my lead? That is always up to you because this is your case, Mr. Smith, not mine. This is your case. But as your attorney, I'm telling you, this will increase the value of your case, and what you're doing over here will decrease the value of your case. What do you want to
All
do?
right.
What do you want to do?
That's great. Well, let me go to this topic, and this may be our last topic in this part two. This has been great. So thanks for this. When you're getting into your final argument, and as you know and I know, one of the things that can be difficult for jurors, because most jurors have never served as a juror before, and most jurors have never tried to evaluate what the hell, how do you put a money on an injury, and how do you put a money on what we lawyers call non-economic damages? And they're not really given, they're given some help by the jury instructions, but not much. So, what are the things you like to talk to them about to help them figure out what makes sense in trying to put dollars to compensate for injuries for your clients?
You know, Craig McClellan, who I think is probably one of the most stellar trial lawyers San Diego's ever produced.
Excellent.
When he does non-economic damages, and I've never gotten a judge to allow me to do this, but he has. Non-economic damages are to compensate for pain, suffering, mental anguish, frustration, anxiety, frustration, humiliation, things like that. On the verdict form, under non-economic damages, he lists each and every one of those items, okay, that apply, and has a line next to it for dollar value. I have never gotten a judge to let me do that. I wish they would because they know they got to put a dollar value on each one of those. You know what I mean? And you start with pain. Well, you go through the facts that your client testified to, the doctor testified to, pain levels 6 out of 10 for 8 weeks, and da 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 da. Frustration, humiliation. Well, he had to go to work with this stupid thing on his neck or whatever, and everyone's talking and taking about him. That's humiliation, ladies and gentlemen. So you explain it all that way. Then you got to get into what's the dollar value on these things.
Right.
These are compensable items, ladies and gentlemen. And if you find that my client sustained economic damages, which is the bills and the lost earnings, you have to find that he sustained non-economic damages. That's the law. You got to do this. You can't just give the medical bills and zero for non-economic damages. That will nullify the verdict. That will be a grounds for a new trial. That is an inconsistent verdict. And so they've got to award something. So what I tell the jury on this when it gets to how you put a dollar value on it, there's a couple different approaches. Um, the per diem approach is good. How much money a day to compensate somebody to go through this? And he went through this for 192 days. That's one way to do it. Um, Pick a number, $100 a day, $25 a day, $50 a day,
Right.
graduates. Maybe the first 6 months, it's $150 a day. Second 6 months, it's $100 a day. Third 6 months, it's $50 a day. Da, da, da. That's one way to do it.
Yep.
Now that minimum wage is up to where it is, not $1.65 an hour like it was when you and I were 16 years old, Monty.
Yeah.
Minimum wage is what, $16 an hour now? I mean,
Something like that.
McDonald's are making $22 an hour now, just to get people to work there. But in any event, an hourly rate is good, and that number really climbs up there when you use now $6, $16 an hour, or $20 an
Right.
hour, and you get to say, and ladies and gentlemen, this is minimum wage. This is what somebody making minimum wage earns, and we're asking for that for the last 192 days, which is so many hours, and you give them a formula is what you have to do. Whatever you use, per diem, per
Right.
hour, or whatever, you have to give them a formula during your closing that explains to them how you reach the number. If you just dump a number out there, and my client deserves $100,000 for the pain and suffering he's gone through for the last 2 years. Jurors kind of go, okay, they're left blank. They're
Right.
left blank. You've been explaining everything all along, and now you just dump this $100,000 on them. Because think about it, this is what the defense does in our cases when they make an offer during their closing. They just dump a number out there. Oh, we think this case is worth $25,000. Boom. Give them $25,000. That's what we're saying, ladies and gentlemen, with no explanation as to why. You need to give an explanation as to why. Whatever method you use or whatever formula you use, you need to get an explanation of why. That way, during rebuttal, you can go up and say to the jury, ladies and gentlemen, I give you a full and complete formula and explanation of how we reach the non-economic dollar value. It's easy to follow along. It's just a mathematical equation, and it's simple math that we learned in high school. So you don't have to worry about algebra or calculus or anything like that. It is multiplication and subtraction and division. So it's easy to understand. The defense on the other side just dumps a number on you. No explanation, no foundation, no basis as to why that amount and not any other amount. So who should you believe? Who should you trust on this issue? Because, ladies and gentlemen, your job right now, when we cut you loose here, the judge cuts you loose, go into deliberation, is to go in there and deliberate and come back and tell us two attorneys here who won, who lost, how little or how much. That is your whole role in this trial, is to weigh the facts and come back and tell us. But you need facts and evidence to form the basis of your opinion. I've given you facts. I've given you information. I've given you what you need to evaluate this case. The defense just dumped a number out there with no explanation. We talk about, ladies and gentlemen, the weight of the evidence all the time. The weight of the evidence is like a scale like this. Here's what I've given you. Defense is giving you that much. Weigh the evidence. Come back and tell us who's right, who's wrong, how little, and how much. Thank you very much.
That's great. Well, Skip, this has been a great discussion. This is a great part two, and I appreciate you imparting your experience and your wisdom. So thanks for all you do, and thanks for all the great work you do for your clients, and thanks for being a visitor and a guest again.
Monty, I come and talk with you anytime you want, brother.
All right, you take care.
You too. Bye-bye.
Bye bye.